Rule 57. Preliminary Attachment. Section 1. Grounds upon which attachment may issue. At the commencement of the action, or at any time before entry of judgment, a plaintiff or any proper party may have the property of the adverse party attached as a security for the satisfaction of any judgment that may be recovered in the following cases. In an action for the recovery of a specified amount of money or damages other than moral and exemplary, on a cause of action arising from law, contract, quasi-contract, delict, or quasi-delict against a party who is about to depart from the Philippines with intent to defraud his creditors. In an action for money or property embezzled or fraudulently misapplied or converted to his own use by a public officer or an officer of a corporation or an attorney, factor, broker, agent, or clerk in the course of his employment as such, or by any other person in a fiduciary capacity, or for a willful violation of duty. In an action to recover the possession of property unjustly or fraudulently taken, detained, or converted, when the property or any part thereof has been concealed, removed, or disposed of to prevent its being found or taken by the applicant or an authorized person. In an action against a party who has been guilty of a fraud in contracting the debt or incurring the obligation upon which the action is brought, or in the performance thereof. In an action against a party who has removed or disposed of his property, or is about to do so with intent to defraud his creditors, or in an action against a party who does not reside and is not found in the Philippines, or in whom summons may be served by publication. Section 2. Issuance and contents of order. An order of attachment may be issued either ex parte or upon motion with notice and hearing by the court in which the action is pending, or by the Court of Appeals or the Supreme Court, and must require the sheriff of the court to attach so much of the property in the Philippines of the party against whom it is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless such party makes deposit or gives a bond as hereinafter provided in an amount equal to that fixed in the order, which may be the amount sufficient to satisfy the applicant's demand, or the value of the property to be attached as stated by the applicant, exclusive of costs. Several writs may be issued at the same time to the sheriffs of the courts of different judicial regions. Section 3. Affidavit and bond required. An order of attachment shall be granted only when it appears by the affidavit of the applicant or of some other person who personally knows the facts that a sufficient cause of action exists, that the case is one of those mentioned in Section 1 hereof, that there is no other sufficient security for the claim sought to be enforced by the action, and that the amount due to the applicant, or the value of the property, the possession of which he is entitled to recover, is as much as the sum for which the order is granted, above all legal counterclaims. The affidavit and the bond required by the next succeeding section must be duly filed with the court before the order issues. Section 4. Condition of applicant's bond. The party applying for the order must thereafter give a bond executed to the adverse party in the amount fixed by the court in its order granting the issuance of the writ, conditioned that the latter will pay all the costs which may be adjudged to the adverse party and all damages which he may sustain by reason of the attachment, if the court shall finally adjudge that the applicant was not entitled thereto. Section 5. Manner of attaching property. The sheriff enforcing the writ shall without delay and with all reasonable diligence attach, to await judgment and execution in the action, only so much of the property in the Philippines of the party against whom the writ is issued, not exempt from execution, as may be sufficient to satisfy the applicant's demand, unless the former makes a deposit with the court from which the writ is issued, or gives a counter bond executed to the applicant in an amount equal to the bond fixed by the court in the order of attachment, or to the value of the property to be attached, exclusive of costs. No levy on attachment pursuant to the writ issued under Section 2 hereof shall be enforced unless it is preceded or contemporaneously accompanied by service of summons, together with a copy of the complaint, the application for attachment, the applicant's affidavit and bond, and the order and writ of attachment on the defendant within the Philippines. The requirement of prior or contemporaneous service of summons shall not apply where the summons could not be served personally or by substituted service despite diligent efforts, or the defendant is a resident of the Philippines temporarily absent therefrom, or the defendant is a non-resident of the Philippines, or the action is one in rem or quasi in rem. Section 6. Sheriff's Return. After enforcing the writ, the sheriff must likewise, without delay, make a return thereon on the court from which the writ issued, with a full statement of his proceedings under the writ and a complete inventory of the property attached, together with any counter bond given by the party against whom attachment is issued, and serve copies thereof on the applicant. Section 7. Attachment of real and personal property, recording thereof. Real and personal property shall be attached by the sheriff executing the writ in the following manner. Real property or growing crops thereon, or any interest therein, standing upon the record of the Registry of Deeds of the province in the name of the party against whom attachment is issued, or not appearing at all upon such records, or belonging to the party against whom attachment is issued and held by any other person, or standing on the records of the Registry of Deeds in the name of any other person, by filing with the Registry of Deeds a copy of the order, together with a description of the property attached, and a notice that it is attached, or that such real property and any interest therein held by or standing in the name of such other person are attached, and by leaving a copy of such order, description, and notice with the occupant of the property, if any, or with such other person or his agent if found within the province. Where the property has been brought under the operation of either the Land Registration Act or the Property Registration Decree, the notice shall contain a reference to the number of the certificate of title, the volume and page in the registration book where the certificate is registered, and the registered owner or owners thereof. The Registrar of Deeds must index attachments filed under this section in the names of the applicant, the adverse party, or the person by whom the property is held, or in whose name it stands in the records. If the attachment is not claimed on the entire area of the land covered by the certificate of title, a description sufficiently accurate for the identification of the land or interest to be affected shall be included in the registration of such attachment. Personal property capable of manual delivery, by taking and safely keeping it in his custody after issuing the corresponding receipt therefor. Stocks or shares, or an interest in stocks or shares of any corporation or company, by leaving with the president or managing agent thereof a copy of the writ and a notice stating that the stock or interest of the party against whom the attachment is issued is attached in pursuance of such writ. Debts and credits, including bank deposits, financial interest, royalties, commissions, and other personal property not capable of manual delivery, by leaving with the person owing such debts, or having in his possession or under his control such credits or other personal property, or with his agent, a copy of the writ and notice that the debts owing by him to the party against whom the attachment is issued, and the credits and other personal property in his possession or under his control belonging to said party are attached in pursuant of such writ. The interest of the party against whom attachment is issued in property belonging to the estate of the decedent, whether as heir, legatee, or devisee, by serving the executor or administrator or other personal representative of the decedent with a copy of the writ and notice that said interest is attached. A copy of said writ of attachment and of said notice shall also be filed in the office of the clerk of court in which said estate is being settled, and served upon the heir, legatee, or devisee concerned. If the property sought to be attached is in custodia legis, A copy of the writ of attachment shall be filed with the proper court or quasi-judicial agency, and notice of the attachment served upon the custodian of such property. Section 8. Effect of attachment of debts, credits, and all other similar personal property. All persons having in their possession or under their control any credits or other similar personal property belonging to the party against whom attachment is issued, or owing any debts to him, at the time of service upon them of the copy of the writ of attachment and notice as provided in the last preceding section, shall be liable to the applicant for the amount of such credits, debts, or other similar personal property until the attachment is discharged, or any judgment recovered by him is satisfied, unless such property is delivered or transferred, or such debts are paid to the clerk, sheriff, or other proper officer of the court issuing the attachment. Section 9. Effect of attachment of interest in property belonging to the estate of a decedent. The attachment of the interest of an heir, legatee, or devisee in the property belonging to the estate of a decedent shall not impair the powers of the executor, administrator, or other personal representative of the decedent over such property for the purpose of administration. Such personal representative, however, shall report the attachment to the court when any petition for distribution is filed, and in the order made upon such petition, distribution may be awarded to such heir, legatee, or devisee, but the property attached shall be ordered delivered to the sheriff making the levy, subject to the claim of such heir, legatee, or devisee, or any person claiming under him. Section 10. Examination of party whose property is attached and persons indebted to him or controlling his property. Delivery of property to sheriff. Any person owing debts to the party whose property is attached or having in his possession or under his control any credit or other personal property belonging to such party may be required to attend before the court in which the action is pending or before a commissioner appointed by the court and be examined on oath respecting the same. The party whose property is attached may also be required to attend for the purpose of giving information respecting his property and may be examined on oath. The court may, after such examination, order personal property capable of manual delivery belonging to him in the possession of the person so required to attend before the court to be delivered to the clerk of the court or sheriff on such terms as may be just, having reference to any lien thereon or claim against the same, to await the judgment in the action.